Good afternoon, and thank you so much for joining us for today's webinar, Representing Protesters with Martin R. Stolar. My name is Lisa Schrade. I'm the National Affairs Associate here at NACDL, and I'm also the administrator for our new First Amendment Strike Force and Mass Defense Unit. NACDL, Liberty's last champion, has a long tradition of fighting to protect constitutional principles and standing up for the individual against the government. In keeping with that tradition, NACDL and the Foundation for Criminal Justice have committed to establish the First Amendment Strike Force and Mass Defense Unit. The goal of this project is to recruit volunteers across the country to be available to assist in representing protesters when the exercise of First Amendment rights results in arrest and prosecution. Specifically, NACDL maintains a database of volunteers, and working closely with NACDL affiliates and others, we connect our volunteers with local groups as circumstances warrant. Our goal is to supplement the great work of so many groups that have long represented those who have faced criminal charges when exercising the right to free expression. Since there are issues common to cases involving mass arrests related to First Amendment expression, NACDL is developing resources to enhance the capacity of volunteer lawyers to appreciate those issues and mount the most effective defense. And so today's webinar, this is part of the effort. If you have any questions during the webinar, please submit them to me via my email at lschrade@nacdl.org. That email address will appear at the bottom of the video throughout the webinar as well. For today's program, we are so pleased to have one of the most experienced and highly regarded criminal defense attorneys with decades of experience in representing protesters. Martin R. Stolar is a fierce defender of the First Amendment and brings extraordinary insight and experience to this program. Mr. Stolar was admitted to practice in New York in 1968 and has been in private practice almost exclusively since then, first with the New York Law Commune, then with a small firm, and as a solo practitioner since 1987. He specializes in criminal defense, but practices in the areas of civil rights and nonprofit tax law for progressive organizations. As part of the National Lawyers Guild's Mass Defense Committee in New York City, he has represented thousands of arrested protesters, including Black Panthers, civil rights activists, anti-war activists, young lords, welfare mothers, Vieques protesters, Occupy Wall Street activists, and environmental protesters. Mr. Stolar has long been a stalwart member of NACDL and the National Lawyers Guild, and NACDL and FCJ express our deepest appreciation to the Lawyers Guild for supporting this effort. And with that, I turn things over to Marty. Thank you so much.
Thank you, Lisa, and let me thank the NACDL and its president, Rick Jones, who I know very well, Norman, the executive director, and Lisa, thank you very much for putting this opportunity together to let me talk to lawyers who are going to be standing up and representing people who are exercising First Amendment rights to protest, right to speak out. I also want to put a special thanks in to Jerry Lefcourt, the president of the NACDL Foundation for Criminal Justice. Jerry is the driving force behind the First Amendment Task Force and Mass Defense Unit. From his experience as a political lawyer way back when in the late 60s and early 70s, where Jerry and I were partners together in the New York Law Commune. The Commune was sort of like the New Left's version of how to practice law. We tried to do as much political work as we possibly could and pay the rent at the same time. It wasn't always easy, and it has not been easy over the years, although that is a position that I personally have maintained over the years. I also want to thank King Downing, who is the Director of Mass Defense for the National Lawyers Guild nationally. And the Lawyers Guild plays a big role in my personal participation in representing protesters, and I hope will play a big role in what is expected to be your participation in representing protesters. Before I go in to talk about this, I want to talk a little bit about who I am so that you have some idea of the person who's sitting up here giving you advice, and you might have some notion of the fact that I might or might not know what I'm talking about. After I graduated from law school in 1968, there was a period of great fervent and dissent. The civil rights movement was in active flow. The anti-war, anti-Vietnam War movement was extraordinarily active, and movements for national liberation and individual liberation among peoples in the United States were proceeding apace. So I wound up joining the National Lawyers Guild. I was a good liberal in law school. I was radicalized to some degree by the police department in Chicago during the August 1968 convention, and I came back to New York with a lot of fire and a lot of desire to use my law degree to represent people who were politically active. That is, I wasn't so much interested in making money, I was interested in supporting social and political movements. To that end, I hooked up with what was then the beginnings of the Mass Defense Office of the National Lawyers Guild in New York City. A woman named Mary Kaufman, who was at that time old enough to be my grandmother, and had been a former prosecutor at Nuremberg after World War II, created the Mass Defense Office in New York in response to massive arrests, primarily at Columbia University in 1968 with the student riots, or what might be known as the police riots back then. The Mass Defense Office was designed so that an arrest incident where 100 or 200 people are arrested could be treated as a single event. That is, rather than having individuals picked off one by one, the defense position was, we're going to go deal with the DA, we're going to deal with the courts, and we're going to treat this as if it's a single arrest, no matter how many lawyers are involved. That strategy worked, not only with the Columbia students, but also massive arrests from a Stop the Draft week that took place, and subsequent to that, a lot of other things. It got me my first 2 criminal trials, which were, not surprisingly, protest cases. A couple of young men were arrested outside the Hilton Hotel protesting Richard Nixon and the war in Vietnam, and were charged with disorderly conduct. Both of them said they were innocent, and so I went to trial. That was my first experience as a criminal defense lawyer, trying a couple of people who claimed they were innocent. Lo and behold, the police officers told a slightly different story than the defendants told. And guess who got believed? My goodness, the police officers were believed. So I got a good early lesson in protest lawyering, and I also got a good early lesson in how to be a criminal defense lawyer, which is to watch out for lying cops. In any event, from those 2 first criminal trials, I started taking protest cases that came through the Mass Defense Office, representing people who got Black Panthers who got arrested for selling the Black Panther newspaper, charged with disorderly conduct, welfare mothers who were sitting in the welfare office demanding changes in the regulations that governed how their children got food. Everybody who got arrested for raising a voice, I came in and was willing to represent. Mary trained me, and she trained a whole cadre of young lawyers at the time who were willing to recognize that protesters were worth our representation, and that the way to represent them was to do it in a mass defense way. From that notion, I've been doing protests ever since. Mostly they come through the National Lawyers Guild office. Occasionally someone will recognize me as an individual and say, hey, would you represent us in this particular case? And I'll do that. But at the same time, I've also become a criminal defense lawyer. I've handled practically every kind of case there is, from homicide to rape to robbery, drug cases, white-collar cases, terrorist cases, you name it. I've been involved in one way or another and have handled probably almost all aspects of criminal defense. But I have to say that protest cases are the most fun. And that's for a couple of reasons. One of which is that you can have a lot of fun with them, and the other is that protesters are extraordinarily interesting people. Among other things, one of the ways that you can have fun is that a lot of protest cases involve minor charges, disorderly conduct, walking in the street, or not obeying a police officer's order. These are charges that are not going to wind up with people facing substantial prison time, but they're minor charges of people who are exercising their rights, and they may or they may not want to contest the cases. It's an easy thing to do. You don't have the same kind of weight that you have where your client is facing 25 years in jail, If your client's looking at 10 days or 15 days, maybe for disorderly conduct, the weight is off and you can have a lot more fun and be a lot more creative with it. But I will say also that I got spoiled very early on in my career by one trial, which I'm going to describe to you briefly, but it influenced the way I look at all political cases and, in fact, all criminal cases. And that was a case called the Camden 28. This was a group of anti-war, mostly Catholic left protesters, some priests and a couple of nuns and their followers, who wanted to do what they could do to stop the war in Vietnam, and their focus was on the draft. And so they basically set up a situation where they burglarized and broke into a draft board in Camden, New Jersey, and started ripping up the draft files so that kids could not be sent to Vietnam. And lo and behold, awaiting them as they walked in and started ripping up the draft files were the FBI, saying, "How do you do? You're all under arrest." Well, it turns out there had been an informant in the group, and 28 of them got arrested and indicted for a conspiracy to destroy government property, as well as the actual destruction of the government property itself, that is, the draft records. Each and every one of them were facing up to around 40 years in jail for an act of protest. They were all caught red-handed, and of course nobody was interested in pleading guilty. What they were interested in doing was putting the war in Vietnam on trial, essentially trying to demonstrate to a jury that their conduct in destroying the draft records was valid, was justified, that the war in Vietnam was such a horror that anything that they could do to stop it was okay. Essentially, jury nullification. Well, by the time we got to trial, there were only 17 defendants left. There were 3 lawyers who represented them. Each of the defendants was either pro se or co-counsel, and the judge in the case, a man named Clarkson Fisher, allowed everybody to stand up and speak. Of course, he had no choice. But what happened in the course of the trial was that there was a twofold defense. One was that the war in Vietnam was wrong, and second, that the government, in arresting these people, overstepped their bounds, that the defendants, while not entrapped, were somehow the victims of an outrageous government conspiracy to entrap them into actually committing the act that they were predisposed to commit. We couldn't use entrapment because entrapment requires that the defendants not be predisposed to commit the act. Each and every one of these folks was totally predisposed towards committing the act. But the informant in the case basically had put together a conspiracy that had fallen apart, and he pulled it back together, provided all the tools and the equipment, and made it succeed. So we were able to convince the judge, through an extraordinary legal work by David Carries, a well-known and well-regarded lawyer in Philadelphia, that the judge could give the jury a charge that said outrageous government misconduct can result in a not guilty verdict. Well, the war in Vietnam was put on trial. The government's conduct was put on trial. Essentially, the tables were turned in what turned out to be a perfect political case. The jury, after deliberating for 3.5 days, found the defendants not guilty. Half the jury, because they had come to believe that the war in Vietnam was wrong, that is, that jury nullification had worked, and the other half because they could not buy the outrageous government conduct that had taken place, that had entrapped, in the moral sense, although not the legal sense, the defendants into committing the act that, of course, they were predisposed to commit. It was the perfect political trial where you put the government on trial for arresting your clients, and the issue that they were protesting about becomes front and center in the courtroom. That is a classic political trial. It was really early in my career. It worked out beautifully. It was gorgeous, and it was just perfect. And that's been the model for how one goes about conducting oneself in a political trial or in a political situation. Now, what does that all mean for you? I'm assuming that the people that I'm talking to are experienced criminal defense lawyers. That means that I don't have to talk about the basics of how to talk to a client, how to interview a client, and what to talk about. It means that you've done cases involving serious criminal defense, that you know what it is to conduct a trial, that you know what it is to represent a defendant who's accused of simple crimes or more serious crimes. But what I'm delighted to tell you, I'm delighted to know, is that the same skills that you have in representing clients in straight cases work extremely well in cases involving protest and the First Amendment. And that's, among other things, that's one of the main differences in representing defendants who are involved in protests. Now, if you think about it, the First Amendment is the key to the whole business. The First Amendment is what authorizes people to gather for free speech and to petition the government for redress of grievances. So that every time there's a protest, there's a First Amendment context in which the protest is happening. Without the First Amendment, there is no protest. So that social, political, economic issues get debated in the streets, they get debated in the parks, they get debated in marches, they get debated in rallies, and it's all First Amendment conduct. All right? Now, the First Amendment, as we all know, is not absolute. And basically, the law is that the First Amendment can be restricted by reasonable time, place, and manner restrictions. That the restrictions have to be reasonable. What does reasonable mean? Well, reasonable means different things to different people. It's what makes horse races, and winds up having different judges say that reasonable means different things. But at least it's a reasonable thing. It can be restricted if there's a reasonable way to do it. It also, restrictions on speech or protest have to be justified without reference to the content of the speech, so that a local ordinance that says no speaking about civil rights matters will go out because it controls content. Now, also restrictions on the First Amendment have to be narrowly tailored so that they can achieve a significant government interest. So that, for example, an ordinance that says nobody can ever march on a sidewalk in downtown Skokie is not going to be upheld because it is not narrowly tailored to serve a significant governmental interest. The significant governmental interest may be we'd like people to have the ability to walk on sidewalks, but protesters also participating in walking on the sidewalk are allowed, and the First Amendment allows them to do it. And finally, the First Amendment says that any restrictions on the First Amendment have to leave open alternative channels of communication. All right? Now, those are generalized terms, and First Amendment litigation is a fairly heavy situation for people that are interested in that. But the reason I bring it up here is that the First Amendment is essential. It'll come up in every single way of a protester's case, whether the protester is charged with disorderly conduct for blocking traffic or the protester is charged with hitting a cop over the head with the cop's billy club. In any event, it's all done in a First Amendment context. And sometimes the First Amendment provides a defense, but most of the time, the First Amendment provides the context in which everything is done. And when I say First Amendment provides a defense, I'll give you an example. Several years ago, there was a large protest in New York on a Sunday that about 600,000 or 700,000 people participated in around climate change. It was a huge event sponsored by large corporate interests and large interests, marches all over the place from the UN over to the Intrepid aircraft carrier, Nobody got arrested. 600,000 people marching in the streets of New York and nobody got arrested. That's great. All right. The following day, however, about 1,000 to 2,000 people decided that the climate change protest belonged at Wall Street. They decided that the heart of what's creating problems with climate change are the Wall Street banks and the Wall Street corporations that are promoting pollution and not taking into account the fact that their conduct is what is leading to global warming. And so they marched from the bottom of Manhattan all the way up to Wall Street, and they were going to turn into Wall Street and protest where the banks and the stock exchange were, except the police had blocked it off, right? So they couldn't get to the object of their protest. Now, so what do? The police say get out of the street, and 110 of them decide to stay in the street. And they wind up blocking Broadway and Wall Street, one of the more busy intersections in New York City, and they defy an order that was given to them by the police that said, you have to leave the street, exit through the street over here on the side, exit the place, please leave the street. Well, 110 of them get arrested, right, including this fellow in the polar bear outfit. If I can get that up on the screen, this is one of the reasons why it's so much fun representing protesters. Here you see one of the 110 people getting arrested. This gentleman is wearing a polar bear costume, and he is somewhat, I guess, a symbolic representation of climate change and the damage that climate change will cause to the polar bear community. Anyway, he's a great guy. He was a great arrested. So anyway, out of the 110 people, he's one of the 110 people arrested. 100 of them take a conditional dismissal, which in New York is called an ACD. It means the case is adjourned for 6 months. If you don't get arrested in 6 months, the case is dismissed and sealed. Right? 100 people took that ACD, including, unfortunately, the fellow in the polar bear outfit. 10 of the people decided that they wanted to make a political trial out of the protest. They wanted to be able to come to court and say, our blocking traffic, our sitting in the street and blocking traffic was justified by the greater damage that is caused by the corporations that are creating climate change that are leading to global warming. They wanted to set up a justification defense, a defense in the environmental community which is known as necessity. That is, that their conduct was necessary and excuses the alleged criminal conduct which is brought against them. And so we tried the case. Right? We had 10 defendants in the courtroom. We had 2 lawyers who were doing it. We tried the justification defense and convinced the judge almost that they were justified in staying in the street. We convinced the judge that he could take judicial notice of the science of climate change, that there was a problem with global warming, but he wouldn't let us go any further to explain why the particular corporations that were on Wall Street were the object of the protest. So he cut that off. But he said, because the police gave an order to leave the street that said exit the area, they said leave the street and go away down this side street, what they were doing was not narrowly tailored and did not leave open the alternative avenue of communication. So the police should have said, get out of the street, continue your protest on the sidewalk. But they didn't. The order that they gave said leave the space. That, the judge said, violated the First Amendment. Right? Even under these narrow, these easy principles that seem like they're kind of vague, this judge said, okay, the First Amendment has been violated. The order to disperse was unlawful. It did not provide any alternative means of communication. All it said was, get out of here and go away from the object of your protest. So the First Amendment provided a defense. Right? It also comes up occasionally in kind of trespass cases. Again, a few years ago, we had a group of veterans against the war, Vets for Peace, who wanted to conduct a vigil and a prayer service at the Vietnam Vets Memorial in New York City. The memorial is sort of inside a city park where there's a regulation that says the park closes at 10. Well, these vets are sitting there saying, what do you mean 10 o'clock? This is a prayer vigil. We can conduct a prayer vigil for our fallen brothers and sisters anytime we want. And so they went to the memorial and they continued on their thing until after 10 o'clock, and then the police arrested the whole bunch of them, right? Being insistent folks that they were, these are vets, nobody tells them what to do. They said, let's go to trial with this case, right? And the whole trial was about whether or not there was a reasonable restriction to say that at 10 o'clock at night, you cannot appear at this Vietnam Vets Memorial. It was a whole First Amendment contest, one way or the other, back and forth and back and forth. Ultimately, we tried the First Amendment to the judge. We lost the First Amendment challenge. But the judge decided he liked the defendant so much. Ultimately, he dismissed the case in the interest of justice. But the First Amendment was the defense that came up. In every other protest case, the First Amendment is part of the content of what you're doing. It may provide a basis for a motion to dismiss, but even if it doesn't, if you're ever trying the case, or even in the context of talking to the media, it's First Amendment conduct. And that's why your participation in representing the First Amendment and representing protesters is so significant. Because if we let the First Amendment disappear, then we all go right down the tubes. All right? Now, the second major difference, aside from the First Amendment, is who the clients are. Now, as a criminal defense lawyer, you get clients who are accused of committing crimes, and the reasons they commit the crimes are all sorts of different things. Greed, passion, anger, a desire to get drugs, or sexual perversions, or even clients with mental disease or defect problems who are not able to control their conduct. There's all sorts of reasons why people get accused of crimes and actually commit the crimes. Protesters are different, right? Not that they're different in the cross-section of people who you represent, because when you represent criminal defendants, big, small, black, brown, orange, yellow, people with polka dots. They come in all shapes and sizes, but they're all accused of the same. Your job is essentially the same, to do the best you can possibly do for your client, either to get them off the charge or reduce the potential punishment for the charge, or to minimize the damage that the system wants to do to them. That's your job as a defense lawyer. Protesters are different in the sense that they have essentially volunteered to get arrested. They're not surprised when they get arrested, or they're annoyed. But by participating in a protest, by participating in a march or a demonstration, there's at least an awareness on the part of protesters that they may be subjected to being arrested because of their participation in the protest. Their motivation to engage in the alleged criminal conduct is not greed, it's not anger. It has to do with their own notions of social necessity, political necessity, and what I need to do in order to make my voice heard. That is, people get up and they vote with their feet. They don't sit in their living rooms. Now, if you yourself, think about it, if you've been involved in any kind of protest or a march or a demonstration, you didn't sit in your living room or your office. You got up and you took the time to go out and to march with people, maybe to carry a sign, maybe to chant some slogans, right? You have no expectation that you're going to be arrested, and yet you know that it's always possible that that could happen out there. So essentially, people involved in protests have made a decision that they're going to risk getting arrested. That means that essentially they become your partner in fashioning a defense, because they've made a conscious choice to engage the criminal justice system because of the way they feel about something that's political or something that's social, then they are directly saying, I want to challenge the system, I'll take the risk, I'm doing it because of my belief in a political principle or a social principle. And that is a different kind of motivation. Right? That's a motivation that says, I've got something to say. And I'm not going to sit around in my office and write letters to the editor. I'm going to put my feet on the street. I'm going to go out. I'm going to march. I'm going to demonstrate. I'm going to hold up a sign. Again, thinking about yourself, right? What motivated you to get up and actually engage in some kind of a march? It had to be something that you felt fairly strongly about, because otherwise you would have sat in your office or sat at home and written a letter or made a phone call to a local representative. Instead, you got up and you joined a march, whether it was a march with hundreds of thousands of people or maybe it was only a march with 10 people. You did something that said, get up and get out and do something. Well, that's what protesters do. And sometimes they get arrested doing it. Now, the arrest is not always their fault, right? A lot of the times, the arrest is the fault of over-policing. The arrest is the fault of bad organizing. A bad route was chosen, or a bad time was chosen, or a bad place was chosen. But whatever the situation is, people get arrested, and the arrests at demonstrations generally, as I've said, generally are minor charges. Walking in the street, interfering with a police officer, trying to control a crowd, refusing orders to disperse, and things of that nature. Mostly peaceful protests wind up with minor arrests. But the protesters themselves want to be involved in the case. They made the decision to get arrested, the ultimate being civil disobedience cases, where we all know that civil disobedience is consciously saying, arrest me, please. I am breaking the law for a higher purpose. It's like the Flood Wall Street people that I talked about before. They sat down at Broadway and Wall Street because they were there for a higher purpose and said, we don't care, arrest us. We are going to be disobedient to any orders you give us to do that. Now, there's a long tradition in this country of civil disobedience, and it's got a very good and solid intellectual underpinning, right? But it happens, and people do it. Now it's gotten sophisticated so that we have elected representatives doing it. We have heads of unions doing it. Occasionally you find a business person getting arrested in a matter of civil disobedience. But they get arrested. And when they get arrested, they need lawyers, right? That's when they come to us, because they get involved in the criminal justice system. Therefore, they need lawyers, and that's what we do. But when they come to us, they're not saying, gee, I'm sorry, I got arrested, I'm really disappointed in this. They're saying is, I did it and I'm proud. So help me make how proud I am part of this court process. That is, I don't want to duck. I want to make it known that this is what I did and the reason that I did it. Your job then is to help them and assist them in making that known. Now, that could very well be that the way to help them and the way to get it done is to get them in and out of court quickly, to work out as quick a deal as you possibly can, maybe even convince a prosecutor to dismiss the case, but to get them out of the legal system so that they can go out and do it again, essentially. Because if you're talking about protesters, they've been motivated to do it. If the protest does not accomplish the particular goal that they had in mind, then they're going to be out and doing it again, time after time after time. And getting arrested is not going to deter them. They want to get it over with. Okay, I'm in the legal system. I don't want to be here. Let me out, and I'll do it again. On the other hand, then you've got some of the protesters who say, let me use the legal system in order to push my point. That is, I want to create a legal defense to the charges that have been brought against me that is related to the purpose of the protest. So that in the Flood Wall Street case, the purpose of the protest was to complain about climate change and the large corporations who are responsible for not controlling it. Well, then the justification defense permits that subject matter to be exactly the same thing in the courtroom. In fact, that has happened in another case that I did, again, another disorderly conduct case, where the protesters were protesting a natural gas, fracked gas pipeline that was going to be situated about 100 yards away from the Indian Point nuclear power plant, which is about 20 miles north of New York City. There were a bunch of folks up in Westchester County and the surrounding areas, also from New York, who said, no, you can't site a high-pressure gas pipeline so close to a nuclear power plant. I mean, that's really dangerous. Don't you think you should take that into consideration? Aside from the other reasons why pushing fracked gas through New York from Pennsylvania shale fields up to Boston for export was really not a good idea for climate change and for global warming. So a bunch of protesters decided that they would try to block the construction road for the machinery that led to the building of the pipeline. And they did that. And a whole bunch of them got arrested. 9 of them got arrested, and decided rather than take an ACD or rather than plead guilty to the minor charge of disorderly conduct, which would get them in and out, they wanted to try the case, and they wanted to put their whole political notion about why they were involved in the protest. That is, that this fracked gas is dangerous, that it's siting next to Indian Point, the nuclear power plant, is dangerous, it hasn't been taken into consideration enough, and we were justified in trying to block the machinery that was going out and building the pipeline. So we tried the case, all right? And again, they were all charged with disorderly conduct for blocking traffic, but we convinced the judge, who was a town justice, a little judge up in a minor justice of the peace place, who only sat for a couple of hours on a Friday, that he should hear a defense of justification as to why the community wanted to the opposition to the pipeline, why they wanted further study, why they wanted to postpone it. And so we were able to put on a whole justification defense, a necessity defense, which included town officials and elected town officials who were opposed to the pipeline, included scientists who were opposed to the pipeline, included a nuclear engineer who was opposed to the pipeline, and it included every single defendant to get up and testify about why he or she was there and why their motivation and their intent was not to create any kind of public inconvenience, annoyance, or alarm, but to stop the company from building the pipeline because it was necessary to stop the greater danger what would happen if the pipeline blew up and the Indian Power nuclear plant spewed off all sorts of stuff all over New York City and the New York City area. The political aspect of the trial, which is what these folks wanted, they were willing to invest their time into doing the trial. And it turned out this trial stretched over like a 6-month period, with 2 or 3 hours on a particular day, or we'll do a full day here, we'll do a full day there. And it took all that period of time to do it because the judge only sat once a week. But each time we were in court, the courtroom was packed, the media was interested in what was going on, and the client's desire to get their message out as to what the protest was about was being done in the courtroom and out. They were able to continue the message that they had been carrying over the course of the next 6 months in Westchester County and the surrounding area, so that further opposition to the pipeline could continue. That is, that the political trial was part of a political movement that the defendants were part of. And my job as a political lawyer was to facilitate their being able to continue the politics of what caused their protest to take place into the courtroom. And it was successful. Of course, the judge convicted them all. But the fact that we were able to put the defense on and carry the campaign that they had been carrying on in many different ways, the courtroom being only one of them, into the courtroom was very significant. And it was actually a lot of fun to do. In that case, we had one lawyer doing 9 defendants. That would be me. Which brings me to sort of the third thing that sort of makes protests different and the model that was created, and that's a sort of a theory of mass defense, where mass defense becomes important where you have a bunch of people arrested, more than 2 or 3, and where under ordinary circumstances you would find that we'd have separate lawyers for everybody and everybody's out gathering their own business. If you do it as mass defense, as you operate and look at the arrest situation as a single event, and then you put on a unified defense, that is, you sit down, you talk to your clients who are participants in this, you talk to the other lawyers who are participants in this, and you can do amazing things to try to even out the imbalance that exists between the forces of the prosecution and the police on the one side, and you as the sole representative of your individual defendant on the other. That's really an imbalance. Mass defense tries to change that and say, okay, you've got 50 people here, we've got 30 lawyers or 50 lawyers representing him, and we're all taking the same position. We all want trials, right? Now, you can manipulate calendars with strategies like that, because no court system is going to be able to give you 50 trials. You're not going to be able to get one trial for each individual person. But if everybody says, okay, that's the position I want, there's going to be some movement on the part of the prosecution, or there's going to be some movement on the part of the courts. So it gives you a chance, if you're working together as a mass, as a unit, to correct the imbalance. It also provides a tremendous opportunity to share information, even without a formal agreement among the lawyers in the case. The interests of the protesters, generally speaking, are identical. That is, that no protester is going to be asked to rat out another protester, primarily because the offenses are minor. And I'm not counting here some of the more serious situations, which we can talk about a little later on, like what happened on January 20th when Trump was inaugurated, where the government chose to take essentially minor offenses and criminalize them to a degree that they are now felonies. Right? 220 people get arrested there. If it is treated as a single arrest, which it was, with not being able to separate individuals out, then it will be dealt with otherwise accordingly. In other words, you've got a much bigger ability to cause the system to react and do things that you want it to do, rather than reacting to what they want it to do. It's when you do mass defense, you wind up representing protesters, but you do it in a way that allows people to talk to each other, allows them to identify unified strategies, allows you to develop evidence from other resources that is otherwise not available. That is, that everybody would be off in their own corner, except if you have a meeting or two and people share the information, then everybody is better off. And in the long run, it works. Some of the larger examples. During the Republican National Convention in 2004 in New York, we had about 2,000 arrests over the course of maybe 4 or 5 days. All of them were dealt with. Everybody was gotten out of jail. And ultimately, by creating a unified defense, the dismissal rate was over 90%. Out of all 2,000 arrests, there was only one felony conviction, which never should have been a felony, because the kid was offered a chance to plead to a misdemeanor for stomping on a cop, and he took it, but then he sort of screwed up later on. But a 90% dismissal rate, and we had maybe 75 or 100 lawyers representing the 2,000 people, right? It was a great result because people were allowed to get back on the street and do what they had to do. Similar situation is Occupy Wall Street, where over the course of a month, we had about 3,000 arrests. Again, we got volunteer lawyers. We had a bunch of people who were interested in either getting out quickly, which the government was not willing to do, or willing to fight it. They were not interested in taking quick dismissals. They were not interested, for the most part, in taking this deferred prosecution, this ACD, because they felt that they were going to get arrested again. So why should they agree to this deferred prosecution, which some of the kids thought was sort of like probation? I don't want that. Well, with mass defense and with pushing the DA's office and manipulating the calendars, we caused them to create a special part for us. We caused them to assign a special judge to us, and we caused all sorts of cases to be dismissed because we were going to fight the cases. And the lawyers met together to decide what to do, what the strategies were, speedy trial dismissals, cases where we said, okay, we want to go to trial in this case unless you give our clients the break that they want. Again, of the 3,000 cases, 90% dismissed, right? Some folks guilty, and again, only one felony conviction out of all 3,000. And I'm happy to say, or not so happy to say, that the one conviction was one that I got. I got a young woman convicted of assaulting a police officer. We can come back to that for a moment, but it was a classic political trial. In any event, mass defense is what allowed a 90% dismissal rate to take place. Nobody got hurt. Nobody went to jail. And the object for protesters is either to keep them out of jail, to minimize whatever the consequences are from running into the legal system. The same is true when you represent straight clients. You want to minimize the consequences of the conduct that they're accused of. The same is true with protesters. Minimizing whatever the consequences are, getting them out so they can do it again, all right? Or offering them the opportunity to use the trial either to show up the police or to continue the protest in the courtroom. And showing up the police is fairly easy to do because cops don't know how to testify truthfully sometimes. And these days, let me get to another section here, kind of what makes things a little bit different, and that is the evidence that's available in protest cases. Now, as criminal defense lawyers, we all know now about DNA, and we also know about video, all right? In protest cases, DNA is not going to be significant, but video is it. Everybody has got video of protests. They're public affairs. The media is out there filming. The police are out there filming. The protesters are out there shooting with their iPhones. The bystanders are shooting. Police are wearing body cameras. Everybody's got video of the protest, right? So if you get lucky or unlucky, you will have some video of the events where your client is accused of violating the law. And depending on the nature of discovery obligations back and forth, you will either disclose the video to the DA, or the DA will have to disclose whatever police video they have to you. Sometimes it's a fight to get it, sometimes not. But in any event, as a source of evidence, video is it. Eyewitness testimony is also significant, but video is it's one of the things that makes protester cases different these days, because everybody wants to shoot the public event. Everybody wants to make a record that they have been involved in, or they've seen their friends, or something happened at a public event, and it's your job to go to dig out that video, both the good and the bad, because you can rest assured that if some idiot demonstrator has taken a shot of a person getting arrested, they put it up on YouTube, right? Hey, this is great. Look at what happened on this date. Meanwhile, they're showing your client, clobbering a cop over the head with a Coke bottle. Not something that you wanted to see on video, right? And the idiot that put it up on YouTube, you would like to strangle, but it's there, and you have to be prepared for it. The reason you have to be prepared for it is that police patrol YouTube. The DA's office patrols YouTube, and they have access to any of the public video that's out there, all right? So, video is going to be there, and it's one of the major sources of evidence. It's not like surveillance cameras from the local bodega or from the corner grocery store, all right? This is video that's going to be out there because everybody shoots it, and one of your jobs is to try to find out what's out there. If it's going to be helpful, that's great. It's a piece of evidence that's going to help your client. If it's not going to be helpful, you can kind of keep it in your file, perhaps, if you're not obligated to turn it over. But there's video out there, and that's what makes protest cases different. They are public, and people want to shoot it. The other aspect of evidence that you have to be aware of is social media. Your clients and your clients' friends will be talking to each other on social media. They're going to talk on Facebook. They'll talk on Twitter. They'll talk about what they want to do, what they're going to engage in, who's going to take the bus, where we're going to stay. All that is subject to the government grabbing it. It's subject to the government seeking your client's account and trying to use it to the detriment of your client. How many times as a criminal defense lawyer have you said to your clients, stay off social media, don't say anything, get off the telephone, they're listening to everything you say. Please don't discuss this stuff. Don't put it up on social media. You can talk to you blue in the face and they do it anyway. All right? In political cases, you've got sophisticated people who use social media to communicate. And if they're not sophisticated enough and they use social media to communicate, they're going to be leaving tracks. They're going to be leaving evidence around. So you have to ask your clients, what have you put up? What have you talked about? Have you written any articles about your arrest? Did you write anything about the events that were going to lead to your arrest? Did you lay out a whole essay about how this particular event was going to be designed to break the law? Hopefully your client didn't say something stupid like that on their Facebook posting, but it happens, and you have to be aware of it in order to defend your client. You have to know where everything, all the good and the bad, and some of your clients, as always, don't always control themselves as to what they say on the telephone and what they put up on social media. Another source of evidence is going to be legal observers. Now, I spoke a little bit about the National Lawyers Guild before. One of the programs that the National Lawyers Guild has, both in New York City, where I come from, and nationwide, is a legal observer program. That is, law students and others who are interested in doing it get trained to be legal observers at protests. That is, they're witnesses. And you'll see them out there. You'll see kids with green hats on that say National Lawyers Guild Legal Observer, and they are out there, having been trained to get out there, at the request of the protest organizer, who've asked for them to appear, and they are potentially witnesses for you. Legal observers are trained to take notes where required and to keep their own notes personal, not to turn them into some central database. All right? And so that's a source of eyewitness evidence. They're not designed, legal observers are not designed to go out and give advice to protesters. They're not designed to tell police to back off, but their presence sometimes causes the police to back off a little bit, because the police don't like to do things where witnesses are available to see them, and they sort of back off every once in a while when they see one of the green hats from legal observers. All right? Legal observers are a source of information. If your client was arrested and legal observers were out there, contact the Lawyers Guild, right, who you should be working with anyway, and I'll get to that later on. But legal observers are a source of evidence that is an independent, semi-independent witness, which is not going to be the same thing as the person who was walking next to your protester defendant, who is your protester defendant's best friend and is going to be subject to impeaching cross-examination because of that fact. So, legal observers are another source of evidence. I guess another source of evidence, and something to be aware of as an evidentiary source, is the fact that the state sometimes uses confidential informants or undercover officers to patrol your protest, to patrol the protest, to see what's going on, and occasionally to induce people to engage in conduct that would cross the line from legal protests to alleged illegal conduct. They're there. And the reason they're there is because the state, if you think about it, the state gets nervous when its policies are criticized. It's one of the things that makes America very unusual, in that we can openly speak and criticize the state, and we can talk about the idiot in the White House. And the fact that Donald Trump is there makes it easier to talk about the idiot in the White House, but we can talk about the idiot in the White House even if it isn't Donald Trump, and we can do that and not get arrested and not get tossed in jail. At least that's the theory in America, right? There are various attempts to try to stifle that and to try to shut that down. And this is one of the things that I think is coming in the current administration. It starts with immigrants being demonized as a group of unlawful individuals, that they're criminals, along with the Mexicans and any other racial stereotype that Donald Trump wants to drag out, and that Jeff Sessions wants to endorse. We have a situation where right-wing demonstrators, who you may or may not be asked to represent, don't ask me to represent them, I won't, but you may be asked to represent them if you're talking about First Amendment protest. It's like the ACLU representing the Nazis or the Ku Klux Klan in Skokie. If you want to do that, and that's the way you think the First Amendment should be exercised, go ahead and do it. I think that they have a First Amendment right to protest, but I'm not going to be the one that enforces that right. Somebody else can do that. I want nothing to do with them. But in any event, this is what's coming from the Trump administration and from the Justice Department, as well as various state legislators. The right to protest is under attack. They don't like the fact that people can stand up and speak their voices out. They don't like the fact that the First Amendment threatens their existence. I mean, we have this idiot in the White House who has to tweet out that he's got a bigger IQ than the other moron has got a bigger IQ. I mean, if he's talking about protesters, then what we're on the verge of, and this is not nonsense. State legislatures are doing it. The feds are doing it too. They're talking about protesters as terrorists, right? That is that you're out there, you're trying to create a change, you're trying to create a political change, and you're doing it by illegal means, right? That's sort of the Patriot Act definition of terrorist activity. And protesters as terrorists are coming down the line. That's kind of what's going to be happening, and that's sort of what some of the state legislatures are talking about when they're talking about limiting the right to protest. They're saying these are lawbreakers, these are not people who are authorized to carry out protests, and besides, they're saying the wrong thing, we don't like what they're saying, all right? That's the bottom line with protesters. They say things that are not happy. They say things that don't make the government happy. And the government then comes down on them and tries to lock up the individuals who are making the speech. The best example is the 220 people who got arrested at Trump's inauguration. They were protesting, and yet they all get arrested and charged and indicted for major felonies. That sends a message that says don't protest against Donald Trump. All right? The government comes back as a repressive force, and again, I talked about the Republican National Convention in New York City. Then we had a pier that they used as a mass arrest processing center, and people got arrested, and they spent 48 plus hours there to keep them off the street so they couldn't protest. That is government repression of protesters. We did everything we could to try to stop that and to try to get the people back out so they could be on the street the night that George Bush got nominated to be president. But the police department specifically had an anti-protester notion in mind. Now, let me talk a little bit about what it means to represent protesters in the course of it. It's sort of nuts and bolts, which is kind of what I do. At arraignment, when they come in, the arraignments, as usual, are always interesting. The object of an arraignment always is to get your client out. We all know if your client's out, they stay out. If your client's in, they stay in. So you do everything you can to get the client out at arraignment. But arraignments in protest cases are interesting because if they are mass arraignments, that means you will be one of several lawyers along with potentially a support group of the protesters and other people who have been involved in the political movement about which the protest took place. They'll come down and they'll support their friends. So at arraignment, you're going to meet not only your client, but you're going to meet your client's friends, your client's supporters, and your client's protesters. Why is that important? Because they're sources of evidence. They are people who you can count on later on. Get names, get phone numbers, ask about video, and you also find out who the other lawyers are who have agreed to come in and represent the protesters. Exchange cards, exchange phone numbers and emails, because ultimately you're going to want to work together to try to figure out the best possible defense for you and your clients, for everybody to do that. And it creates a situation where the beginnings of a mass defense effort, if that many people are arrested, can begin. Lawyers talk to each other, clients talk to each other, you find out if there's video, you find out what the charges are, you find out what the DA's office attitude is for a group, not for the individuals, but you have a better understanding of what's going on with the group. One thing at arraignment which sometimes comes up, and that is cursio problems. That is problems where a judge says one lawyer cannot represent two defendants or more than two defendants. Very often, cursio, if you've got a really nasty judge, is a problem. But cursio is waivable. And if a judge ever raises it, and it could happen right at arraignment or shortly after that, then your defendants, your protesters, are going to be more than happy to say, yes, the same lawyer can represent me. I understand there's a potential conflict of interest, et cetera, but in a disorderly conduct case, you're not likely to wind up having one person cooperate against another person because it ain't worth it. It's just not going to appear. That doesn't mean it doesn't happen in more serious cases where the stakes are higher and where people are arrested in protests and charged with felonies, and that sometimes happens too. The classic protest that resulted in felonies is what happened in Attica Prison in 1971. A whole bunch of prisoners rebelled, and in a protest about racism in the prison, about the prison conditions, about how they were being treated or mistreated, they took over the prison for 4 days. These were protesters, right? Now, the state, Nelson Rockefeller being the governor at the time, was extremely repressive and came in with guns blazing 4 days later and killed 43 people, right? Not being satisfied for the turkey shoot that killed 43 people, they then indicted another 50 people down the road, and so we had 50 serious felonies to deal with coming out of the Attica Prison Rebellion, a couple of them dealing with murders, one of a prison guard, a couple of inmates that happened during the course of the protest, and various other people for various conspiracies of assault and taking over this and taking over that. Again, it was a unified mass defense effort. Lawyers came in from all around the country, from Detroit, from Chicago, from Boston, from New York, and from the West Coast as well, to represent what became known as the Attica Brothers. And after a lot of difficulty, I assure you, if you thought that representing people who were protesting on the street was difficult, representing a bunch of inmates who have been locked up for a long time and who decide they are now protesters is not so easy either. But it happened, and it was successful. It happened. Ultimately, all the indictments save one wound up getting dismissed. Right? Nobody suffered as a result, ultimately, of Attica, and eventually we were able to get some money for the 1,700 people who were in D-Yard, who were the subjects of the assault by the state police and by the prison guards. But that's an example of a protest that's serious. You know, things are on the line. Life is on the line. People are accused of assaults. People are accused of murder. There was even a couple of indictments that they threw in for sexual abuse between the inmates during the 4-day period that the inmates were in control of the institution as part of their protest. Why did the government toss that in? I guess to throw a little dirt on the inmates, to show that maybe these protesters were not so clean. Well, they were inmates, but they weren't clean. Anyway, I could talk for hours about some of the more interesting cases that I've been involved in, but I wanted, before I take some questions which might be out there, I just wanted to say my perspective on what this task force is about. The National Lawyers Guild has been doing this at least since 1968. There's been a mass defense office nationally. There are mass defense offices locally in various cities. New York has got what I would say is the most sophisticated mass defense office that exists in the country. We train legal observers. There's jail support people. We get notice that an event is taking place. We have legal observers out there arresting them. We have a pool of lawyers who are called upon to come into court and represent people. We have older lawyers like myself who conduct CLEs to train younger lawyers. And there hasn't been a protest arrest in New York that we haven't had our hands in. And it's extremely sophisticated. It works like clockwork. It's not as sophisticated in other cities, but there's a mechanism there, and there is experience among guild lawyers who have been doing this for a long time and representing protesters for you guys to work with. Right? The task force, the First Amendment Task Force and Mass Defense Unit of the NACDL should and will work in conjunction with the National Lawyers Guild. And here are a couple of emails for you to be aware of. One is my own, right? That's me, Martin R. Stolar. You can call me, you can email me, you can consult with me. I'm more than happy to talk to people about protest. Protest lawyering is what I've done. I've done it from the beginning of my career. I'm a good, sophisticated criminal defense lawyer, but I have this little weird specialty in representing people who get arrested for opening their mouths and saying things. The second, what you have up there, is King Downing. King is the director of National Mass Defense for the Lawyers Guild. He's based in New York, but he travels all over the country, and sometimes this collaboration works. For example, in Charlottesville recently, we thought that there were going to be a huge number of arrests. That is, the Guild was called out to provide legal observers and to participate, and when we thought about it, King reached out through the NACDL and found some Virginia barred lawyers who were willing to stand up with the Guild lawyers who were there in the event that people got arrested on the spot. It turns out, because the police were kind of asleep at the switch or had made a decision to be asleep at the switch, not very many people got arrested. I'm not sure that's going to stay. One of the things that I think about that conceivably could happen is there is still a statute on the books called the Wrap-Brown Law. It's the crossing interstate lines to incite a riot. It's what the Chicago 7 were accused of, that as you cross the state line, you go to a demonstration, and they determined that because there was some ruckus at the demonstration, it was a riot, right? Well, becomes a federal crime. I suspect that the Justice Department is going to resurrect that, and we're going to have some prosecutions of protesters and demonstrators who go from city to city to cross state lines. Anyway, the Lawyers Guild is here. The bottom on the screen that you saw are National Lawyers Guild mass defense contacts all over the country, so that wherever you pick up a case or wherever you try to decide you want to participate in the local effort to represent protesters, the Guild contact is there for you to work in conjunction with. The person is not necessarily a lawyer, but the person is the contact in that particular city or that particular region. And here's a network of folks in the Lawyers Guild who have been doing this for years. There's no reason to duplicate efforts. There's a very good reason to work cooperatively and for everybody to work together. The reason being, the object here is to get our clients out, right? To minimize the damage that's caused to our clients who get arrested for protesting, or to create situations to carry on the protests in the courtroom by doing a political trial. Now, getting your client off in the same way that anybody accused of a crime, either you could try the case straight without any kind of political content, and that often happens. The cop was lying, the cop was mistaken, the witness says this happened or that happened. You just try a straight case, regardless of what the charges are. Not always minor charges, sometimes a little major, but in any event, working with the Mass Defense Committee, working with me, working with King, the object being, let's get the protesters' asses back on the street and keep them out of jail. That's what protest lawyering is about. Now, I understand that we may have a couple of questions, and I'll do the best I can to try to answer them.
Thank you so much, Marty. We have a few questions. I'm just going to start with the first one. In civil disobedience cases, what is the defense when the court denies the request for a necessity instruction and/or bars you from using the necessity defense, assuming the judge has found that the defense has failed to put forth sufficient evidence to get a necessity instruction?
Well, I mean, the question is really, what do you do with the judge who won't charge the jury the way you want the judge to charge the jury? You yell and you scream and you say, I'm going to get you on appeal, but there's not a whole lot you can do. The best that you can do if the judge refuses to charge necessity is to say, I'm going to do this on appeal, but then to try to bring it in as part of your client's intent. In other words, there's a mens rea and an actus reus. If you can try to talk about the mens rea, that your client's intent was not to violate the law, but your client's intent was to do something different, then maybe you can get away with it. Maybe you can get to a jury. Maybe you can get to a jury without being throttled for basically dancing around jury nullification, which is really what you're looking for, which is okay. You know, if you've been allowed to put the evidence in front of the jury, then the jury's hopefully going to want to acquit your client, and you want to give them a reason to do so, even though the judge is trying to restrict your ability to do that.
Thank you. Then we actually just got two jury-related questions. In an attorney-led voir dire scenario, what questions would you suggest to deselect bad jurors for a First Amendment-based trial?
Well, I mean, it's about voir dire, and how do you voir dire a jury for protest situations? Again, jury selection is as individual as as can be there. What I try to do in jury selection in protest situations is ask people if they've been involved in demonstrations, or if they know people who've been involved in demonstrations, and to get them having a discussion about what a demonstration is and about what it means to be involved in a demonstration, they or their friends, so that I can figure out if I've got a person who says anybody who's involved in a demonstration is by definition a bad person, I'm likely to convict them. So to get their attitudes about the First Amendment, about protests, is one of the things that I would try to do in a voir dire, how they deal in conflict situations, and how they, not questions about how they decide how to tell the truth, because that's always in everybody's voir dire, but here, have you participated? Do you know people who participated? What do you think of people who participate in demonstrations?
That's great.
Lisa?
When explaining to a jury that this is a First Amendment conduct, do you request a special jury instruction explaining the First Amendment and how it exculpates the client?
Well, I've yet to be able to get a judge to give a First Amendment defense jury instruction. Most of my First Amendment defense situations have been in bench trials without a jury. But I recently did do a case of a protest at a community board meeting where the raucous demonstration was being led at the community board meeting, and the person was basically being charged with making too much noise at public and refusing orders to stop the protest. We convinced the judge basically to say that you have a First Amendment right to protest, that to the judge that gave that to the jury, but it was balanced by the prosecutor's request that even if you have a First Amendment right to protest, you can still be arrested and accused of violating the law. The First Amendment does not give you a defense to breaking the law. So it goes both ways. In that particular situation, it was a very sympathetic jury. The protester was very sympathetic. The issue of gentrification in the community was very sympathetic, and it worked. She got acquitted in spite of videotape that showed her doing exactly what the police said she was doing. It was delightful.
Great. Then we had several people ask if you could cover the January 20th inauguration protest a little bit more in depth.
I really don't want to do that. It's an open and an active case.
Right.
I am not one of the attorneys in D.C. who is doing that case. I am occasionally consulted by some of the defendants in that case, some of whom are from New York. But it is not my case, and I feel very uncomfortable commenting on it. What I do know is that the government made a big mistake in indicting 200 people for felonies for being involved in a protest. The problem comes when the government is unable to differentiate between people who are accused of engaging in violent or semi-violent conduct and people who are hanging around and watching what they're doing but not engaging in that conduct themselves. Criminal responsibility is still an individual measure of how we punish people. There is no such thing as a group, except for conspiracies, which is maybe why they're going after everybody's Twitter accounts and social media accounts. Maybe they're going to show there's a big conspiracy to demonstrate in D.C. against the President of the United States being inaugurated. What a shocker. Big surprise. If the judges let that go on and to become a felony trial and to do a whole bunch of felony trials, then we are really in trouble. The entire country's in trouble, and questions about creeping fascism are going to get answered more quickly than I would like to see them answered. Part of our job, I think, is to stop that from happening.
Another question. What kind of pretrial release issues have you encountered when trying to argue for reduced bonds or non-monetary bonds for people who have been a part of protests that have turned into riots or turned violent or had messages that the prosecutor has characterized as unprotected speech?
Bail is pretty much the same for protesters and for non-protesters, I would say. My experience is that protesters more often than not have roots. They have, as a class, they're a fairly educated group with jobs and roots in the community, so that bail arguments are pretty strong, unless they've come in from out of state, in which case then you have the problem of dealing with an out-of-state defendant, which in a protest is no different than in a regular case. The difference in a protest is that in arguing with the judge, again, the First Amendment is the context. And so you don't have to talk about, well, this is the lowest person in a big drug conspiracy, or that the person is involved in a drug conspiracy or a robbery conspiracy or a gun running conspiracy. Those are crimes that judges' ears go up and they think, oh, these are bad things, therefore I'm going to be much more likely to keep the person in jail. If you put out the First Amendment context, that this is demonstration, this is about social policy, it's about political policy, it's not about greed and drugs and guns, then that context says to the judge, this is not a bad person. This is a good person. This person is so concerned about conditions in the community that if you let them out, they're going to continue to talk about conditions in the community. They're not going to continue to commit crimes. They're not a danger to the community unless you, judge, have decided that speech is dangerous enough to incarcerate somebody. We haven't gotten there yet, and hopefully we never will.
We have one more question.
Okay.
Saying, what are the lessons of Ferguson, and how can defense attorneys prepare for mass defense and political trials in the post-Ferguson era?
Well, I mean, the lessons of Ferguson are that police still don't know how to treat people that they arrest, and that people are going to protest, particularly the racially influenced deaths all across the country. That's what happens with Black Lives Matter, and how to prepare for those, I don't know. Maybe the best way to prepare for them is to make yourself available to provide pre-demonstration legal counseling to people who are going to get out there and try to do something about it. If you want to be an activist and be on the street, then you can be prepared to get on the street. But if you want to be the lawyer, then make yourself known, if you possibly can, to leadership in the activist community. Tell them that you're available if people get arrested in the course of a demonstration. Tell them you're available potentially to talk to them pre-demonstration, and there we got to be a little careful about what kind of advice you give to people who are going to be involved in potentially illegal conduct. They can ask you, if this X, Y, and Z happens, what are the legal consequences? But you got to be very careful about saying, do this, do that, and do the other thing, because you don't want to become part of the conspiracy by providing the legal advice. It's a little fine line, but it's one that all of us always get asked about, and we have to live with. All right? So if I think we're pretty much at the end. Again, representing protesters is really no different from what you do every day. Negotiations with the DA's office are the same. I've got a really strong case, you should give me a decent plea, or I've got such a strong case, you should dismiss it. Forget whatever's good is, we're going to trial, and you try to set it up for trial, or because there are very often minor charges, to try to dispose of those minor charges in ways that permit your client to go back out and demonstrate again. And again, it's a wonderful opportunity to train younger lawyers. The DA's office, the prosecution offices, often use protest cases as a way to train their younger lawyers, because they're not letting some heinous murderer roam the streets by giving it to a rookie. It's only a protester. Well, the protesters actually are more powerful sometimes. They have a lot to say, they change policy, they change the way we view policy, and it is well worth all of our efforts in representing protesters, including the Mass Defense Unit of the NACDL, the First Amendment Strike Force, which is a great idea, and working totally in conjunction with Mass Defense of the National Lawyers Guild, both of which I totally support and work with, and I hope this is going to work way down the line in the future. So I thank you for participating. I thank you for being part of the task force. And if there's any way that we can provide any more information or additional information or answer any questions, please do so. Thank you very much.
Thank you so much, Marty. And we will make sure to make the contacts on the PowerPoint available to everyone after the program as well
Very
on the
good.
website.
Thank you.
Thank you.